Welcome, everybody. Welcome to the Law of Self-Defense show. I am, of course, attorney Andrew Branca for the Law of Self-Defense, covering the Christopher Schurr murder trial over the shooting death of Patrick Lyoya in Michigan in 2022. 3 years later, the murder trial is finally taking place. We covered live stream the entirety of the trial proceedings today, over 8 hours of live streaming. Thousands of people showed up. In fact, I think I just took a look, and we had 14,000 people joined us at one point or another of today's live stream. This is the end of day summary, where I quickly go over a review of my notes. And I have about 50 pages of notes. I'd like to get this done in 10 or 15 minutes, this summary. So, by the way, if you're watching this, if you like our content and how we present it, the best thing you could do for us is give us a subscribe. We're just about to hit 212,600. I need 6 more subscribers. So if you're watching this and you haven't yet subscribed to Law of Self-Defense on YouTube, now would be the time to do exactly that. All right. So we had, let's see, 5 witnesses today, all defense witnesses. We're currently in the defense case in chief. The state rested yesterday morning. The first witness of today was the 5th defense witness. He had begun cross-examination yesterday. This is Captain David Siver, Grand Rapids Police Department, a great witness for the defense, and the defense made too little of him, unfortunately, as this defense tends to do. If you haven't watched our coverage of this before, this defense team is extraordinarily weak, extraordinarily low energy. Christopher Schurr absolutely deserves better. This Captain David Siver basically kept handing the defense the meat that they needed to pursue, to dig out in defense of their client, Christopher Schurr. And the defense would just not see it, not focus on it, just move on to the next thing. It was a terrible lack of exploiting the tremendous value that Captain David Siver was offering this defense. By the way, every police officer presented in this trial so far, who's an officer with the Grand Rapids Police Department, has been presented by the defense, not by the prosecution. The prosecution did not call a single police officer from Christopher Schurr's department, the Grand Rapids Police Department. So the first witness today was the continuation of the cross-examination of Captain David Siver. Prosecutor Becker was his usual bullying, abusive, yelling, tossing documents, arrogant self, didn't really make any headway with the officer, did a lot of shouting. The cliche in the law is when the law is on your side, you pound the law. And when the facts are on your side, you pound the facts. And when neither is on your side, you pound the table. And that's what Becker has been doing pretty much this whole trial. And Prosecutor Becker continued to do that with Captain David Siver. Then we had the next witness was another police captain from Grand Rapids Police Department, Chad McCursey. Again, another great witness for the defense, very favorable to the defendant. Christopher Schurr clearly believes that Christopher Schurr acted reasonably. Every officer asked whether or not Christopher Schurr was acting as a reasonable officer when he fired that shot into Patrick Lyoya has said, yes, he was. Every single one. Grand Rapids Police Department, Chad McCursey, like David Siver, both 20-plus year officers, lots of training experience and responsibilities, and both strongly in support of the reasonableness of Christopher Schurr firing that fatal shot into Patrick Lyoya. The next witness was defense witness number 7. This was Jason Gaddy, again from the Grand Rapids Police Department. Again, a very experienced police trainer within the department, had helped train Christopher Schurr through his academy, had helped train Christopher Schurr at the multiple annual trainings that every police officer in the department is required to go through. Never served on a street role with the defendant, Christopher Schurr, but had a lot of training for him. Very impressive guy on the witness stand, very calm, cool demeanor. Had, interestingly enough, refused to meet with the prosecutor investigator, who's from the Michigan State Police, not from the Grand Rapids Police Department. And Jason Gaddy, again, stepped through all of the training, what officers are supposed to do, what a reasonable officer is supposed to do in the circumstance that Christopher Schurr found himself, and again testified under oath when asked that Christopher Schurr was acting as a reasonable officer would act when he fired that fatal shot into Patrick Lyoya when Lyoya had seized control of Schurr's taser and was turning into Officer Schurr to use that taser upon him. Then we had defense witness number 8, Lon Bartel. This guy was kind of interesting. He works for Vertra, a shooting simulator training company. I've used their products. They project images of use of force encounters on a screen, and officers or anybody can use an infrared pistol to solve the problem, shoot at the target, and so forth. He's done a lot of study on exercise, physiology, and psychology. Basically, he was there for not a very complicated reason, but to explain to the jury that when you're in a fight for your life, you get exhausted. And as you get more exhausted, you have fewer defensive options to work with, and you're inexorably pushed to either losing the fight or ultimately going to your deadly force service pistol to defend yourself. And he went through painstaking detail on how exhausted defendant Christopher Schurr was getting over the course of this 2.5-minute fight with Patrick Lyoya until Lyoya had seized exclusive control over the officer's taser, and Christopher Schurr was compelled to pull his service pistol and fire that bullet into Patrick Lyoya, ending the fight. On cross-examination of Lon Bartel, Prosecutor Becker ridiculously argued that, hey, a 2.5-minute fight's not that big a deal. There's no way this defendant should have been that exhausted that he had to go to his gun to fight off the taser in the hands of Patrick Lyoya, because after all, professional MMA fighters, they have rounds of as long as 5 minutes. And then they do another round of 5 minutes. It works for them. They're still effective at being able to fight and defend themselves. And Lon Bartel, this witness, had to explain, and those are professional MMA fighters that do nothing but that. They train 3 times a day in training sessions that last 2 to 3 hours each, and they do it for years to develop that kind of physical conditioning and those skill sets. That's not what police officers do. Police officers work shifts every day in patrol cars securing our neighborhoods. They are not professional fighters. They cannot be expected to perform at the level of a professional MMA fighter. Obviously, also, of course, and I can't remember if this was said in the testimony, but those MMA fighters are in a ring. They're in a ring with referees and rules. No one's going to be allowed to beat each other to death in that ring. Neither one of them is armed with a gun that the other guy's going to take and use to shoot them dead in the ring. Completely different set of circumstances. And then finally, we had the last witness of today, defense witness number 9, Mark William Kroll, a biomedical scientist in bioelectricity, has done a lot of work with Axon, has spent 20 or 30 years investigating the effects of electricity in the human body, including Axon, the company that makes the taser. Wore a bow tie, looks exactly like you would expect an older, gray-haired, bow-tied PhD to look like. Very, very credible. Many, many years of publications and research on all these issues. Obviously, far more impressive than the state expert Seth Stoughton, that hack. And Dr. Kroll explained many of the risks that come with the taser, including drive stun to the neck, can incapacitate someone to the same effectiveness as if they had been shocked with the probes, maybe worse. Damage can be caused, permanent damage, loss of the eyeball can be done to the eye. Third point of contact, if someone's laying on a probe in the grass, can result in neuromuscular lockup. And what else did he have to talk about? So mostly all the ways in which the taser, even a taser with probes fired being used in stun drive mode, can still result in NMI and cause serious incapacitation and injuries in other ways. He also spoke about Seth Stoughton's testimony and said, I saw that guy's testimony, and to be kind, I disagreed with a lot of it. In fact, I wondered about his background. So I called Axon which has records of everyone who's ever been trained in the use of a taser. And I asked them if they had any records of Seth Stoughton, who claims police experience some 20 years ago. If Seth Stoughton, the state's expert who testified about taser use, if he had ever been certified to use a taser. And the answer is Axon has no record of him ever being certified to use a taser, which tells us that even when Seth Stoughton was briefly a police officer, he'd never carried a taser, he'd never been trained in its use, and he'd certainly never used one on someone in the capacity of a police officer. The state objected to that line of questioning, and of course, this dopey judge in this case, double-digit IQ at best, sustained that objection, but it nevertheless got out in the hearing of the jury. Then on cross-examination, again, Prosecutor Becker put on his bully outfit, lots of yelling, kept demanding, isn't it true that you wrote in this paper and you wrote in that paper and you wrote in this PowerPoint presentation and you wrote in this book chapter that tasers rarely result in death or serious bodily injury? And Dr. Kroll says, yes, that's right. Tasers rarely result in death or serious bodily injury. Of course, the point Becker was trying to make was, well, therefore, Officer Christopher Schurr had little to worry about when Patrick Lyoya stripped him of possession of his taser and apparently intended to use it on the officer imminently. No concern, because tasers only rarely cause death or serious bodily injury. At which, of course, Mark Kroll, defense witness number 9, biomedical scientist, said, yes, that's in the hands of trained people using the device in the manner designed and intended, not the device being used by unlawful criminals committing violent assault upon the officer and seizing the officer's weapon and using it with no training and no care for avoiding serious injuries to the officer. When an officer uses a taser, he's been trained in exactly how to use it safely without causing serious injuries, and he has an interest in not causing serious injuries. None of that is true when the taser is in the hands of a criminal using it against the law enforcement officer trying to make his lawful arrest. The other thing that Prosecutor Becker seemed to think was important was that there's no cases of an officer being stripped of his taser, shocked with it, and then being killed by that suspect. And Dr. Kroll pointed out that, well, this was a lot like saying, we don't know what would happen to someone if they jumped out of an airplane without a parachute, because the only people who jump out of airplanes have parachutes. Maybe someone could jump out of and they live, right, with the parachute. Maybe they would live if they jumped out of the plane without the parachute. No, that's not what's going to happen. In this case of police officers who have had their tasers taken, not ending up dead by the suspect, the reason they don't end up dead consistently in all the cases known is because when the suspect seizes the officer's taser, the officer does exactly what Christopher Schurr did here. The officer shoots the suspect. That's why the officer doesn't end up dead, because he transitions to his service pistol to save his own life in self-defense. Not a good day for Prosecutor Becker, who really is not a very good lawyer or a prosecutor based on what I'm seeing in this case. Of course, his case is really crap. So to some extent, that limits what somebody can do. I don't know that Prosecutor Becker would do a much better job here if he had better facts and better law than he has. There were a few questions from the jury. One of them was notable. It asked if it asked something about getting, what was the phrase they used? I don't have to go through these training programs, but basically if the officers get DEI training, cultural sensitivity training. And they asked that of one of the trainers, because in Michigan, the jury can submit questions to the judge to ask of the witness on the witness stand. And one of the questions was, did the officers get, cultural sensitivity training and DEI training? That's notable because if that person is not one of the alternates and ends up on the jury, that kind of question suggests, at best, Christopher Schurr can expect a hung jury in this case. That doesn't sound like someone who's going to vote not guilty for the officer who shot Patrick Lyoya, a black man, and of course the officer is white, in the back of the head. But of course, a hung jury would be a win for Officer Schurr. Well, former Officer Schurr. It means I'm sure they would retry him again a second time. But in the second trial, maybe he'd have a much more capable legal defense team than he has in this trial. Because a really effective criminal defense team would go a long way to securing his acquittal. The facts and the law are squarely in Chris Schurr's side. He's just stuck with a legal defense team that has negative energy, seems to only want to get the day over with each day, is more concerned with efficiency, keeps telling witnesses, their own witnesses that they call. Listen, I could ask you all these questions that would be helpful for my client, but I previously asked those of a different witness, so I won't repeat myself here. Well, that's good if your primary concern is efficiency of the proceedings. It's not good if your primary concern is the best interest of your client. You ask the question again, especially when you know you're going to get a favorable answer from your witness. And you ask it again, and you ask it again, and you ask it again, just like these defense attorneys have had many opportunities, especially in front of all these witnesses today, these police officer trainer witnesses, to ask them, let's step through the videos again. And at each and every point, was this the reasonable conduct of an officer? Yes. Was this? Yes. Was this? Yes. Was this? Yes. And the firing and the fatal shot, was that? Yes. They should be stepping through those videos with every one of these police trainer witnesses every single time. If only so, when they get to the end of the trial and they have to do their closing argument, they can tell the jury in closing, look, you saw us. We stepped through this fight frame by frame with every police witness with training expertise, and every single one of them said this was a reasonable use of force by this officer, by this defendant, at every moment in that confrontation. But if you don't ask those questions of the witness, you cannot make that claim in closing argument. A real missed opportunity by these defense lawyers. Again, they seem to be prioritizing efficiency over effectiveness, and that's not in the interest of their client. So, Dr. Kroll was the last witness of today, defense witness number 9. The court recessed for the day, and we'll be back again at 9 a.m. Eastern time tomorrow morning to be live streaming the case then as well. Unfortunately, I don't know how many witnesses the defense has to go. Again, the state already rested. They rested yesterday morning after roughly 2 days of witness testimony. I'm not sure how much the defense has to go, but the way they prioritize efficiency, it wouldn't surprise me if we wrapped up testimony tomorrow. We'll have to see what happens. All right, let me take a quick look and see if we have any questions that came in during this wrap up. It doesn't look like we did. Let's see. Clay says, law self-defense member Clay says, if a criminal loses the fight, he goes to jail. If the law enforcement officer loses the fight, he dies. Right. Exactly right. Let's see. Law self-defense member Phil says, I think this was generally a good day for sure, but his defense team wasted so many opportunities to make it a great day. I agree. On the flip side, I don't think Prosecutor Becker is helping the prosecution with his petty little bad manners towards the defense witnesses and adolescent petulant rants. Yeah, so here's a little thing that the prosecutor does. Whenever the defense wants to approach the witness, they ask the judge, Your Honor, can I approach the witness to show them a document or an exhibit or whatever the case might be? That's what you're supposed to do every time. This prosecutor doesn't bother asking. He just throws documents in front of the witness on the witness stand. That is contemptible behavior in a courtroom. And a juror actually asked about it. A juror wrote out one of their questions to the judge and asked the judge, what's the deal with walking up to the witnesses without asking permission from the court to approach? And the judge just decided, I'm not going to answer that question. The judge is extremely biased in favor of the state here. Lets the state prosecutor get away with a ton of stuff, invariably, with rare exception, rules against the defense on any kind of objection. Now, in fairness, the defense is also extremely inept at arguing their position on objections. So they give the judge the opportunity to rule against them, another way in which they're not effective for their client. Let's see if there's anything else. I think that's about it. So I'll go ahead and wrap up at this point. It's been 8 hours, 30 minutes, and 30 seconds. Again, if you could hit, we did. We crossed 600. Thank you so much. 212,611 subscribers. Our goal is 1 million subscribers for this channel. We're getting a little bit closer every day. Now we're at 21.26%. And it's only possible because of all the support you provide. We love having all of you in the law of self-defense community. The last thing I'll mention before I sign out is, once again, you can get our book, The Law of Self-Defense Principles, your handbook for being hard to convict if you're ever compelled to defend yourself, your family, your property. Check it out on Amazon, 5-star rated, but don't buy it there. They'll charge you $25 for the book plus shipping and handling. We only ask you to cover the cost of shipping the book to you. The book itself is free, and you can get that at lawofselfdefense.com/get the book. lawofselfdefense.com/get the book. Get it for yourself. Get more than one copy for yourself. Get it for your family. Get it for your friends. Anyone you care about who you don't want spending the rest of their life in a cage simply because they had to defend themselves. They need this book. Anybody you know with a gun needs this book. You can get it at lawofselfdefense.com/get the book. Get the book. Whew. All right, another long day. I expect it'll be another long day again tomorrow, but it's always fun hanging out with the law of self-defense community. I'm going to go ahead and wrap things up at this point. Thanks again. Let's see how many joined us today. Let me do a little refresh here. About 15,000 of you joined this stream at one point or another today. Thank you for your ongoing support. It's really appreciated. Looks like all the super chats are taken care of. Shane, thanks as always for being here. I saw Will Parker in the chat, another one of our mods and a great self-defense trainer up in Montana as well. Thanks, guys. I really appreciate all your help with the moderation. And until tomorrow morning, 9 a.m. Eastern time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.